The Eastern Caribbean Supreme Court, a court which has evolved over the past 4 decades.
The Supreme Court is one of the unique courts in the world because it is at the same time an international court as well as a domestic court for 9 separate jurisdictions.
The court has maintained a very good reputation for integrity and for independence.
The Eastern Caribbean Supreme Court has been the first court in the entire Caribbean region to move from the old rules regarding civil procedure and to institute a modern system of civil procedure called the Civil Procedure Rules 2000. And that is no little achievement, that's a big achievement.
The Eastern Caribbean Supreme Court, serving the people of OECS member states and territories from Anguilla and the Virgin Islands in the north to Grenada in the south. The Eastern Caribbean Supreme Court, an evolving court. Inaugurated in 1967, the West Indies Associated States Supreme Court, now styled the Eastern Caribbean Supreme Court, was initially housed in the West Indies Associated States Secretariat in Grenada. Its predecessors were the Court of Appeal of the Windward Islands and Leeward Islands and the Supreme Court of the Windward Islands and Leeward Islands. Retired Justice Eric Bishop, one of the inaugural judges of the Eastern Caribbean Supreme Court, recounts those early days.
It was almost the only course open to the territories. They could not each have their individual Supreme Courts, and therefore it was almost a sine qua non to have a unified regional court. It was a new experience for all of us.
The first Chief Justice was Mr. Justice Allen M. Lewis of St. Lucia. He was assisted by 2 appointed Justices of Appeal, Justices Keith Gordon of St. Lucia and Percy Lewis of St. Vincent. The court was also inaugurated with 5 High Court judges, Justices Elwin St. Bernard of Grenada, Alan Louisi of St. Lucia, Eric Bishop of Barbados, Eardley Glasgow of St. Vincent, and Neville Peterkin of St. Lucia. The learning, regional knowledge, and sensitivity of these Caribbean men were put to the test from the very inauguration of the court.
Immediately it started, it faced challenge of St. Kitts, Nevis, Anguillan separatism that had direct challenges in law for the court.
The first Chief Justice, he came here after we had some tumultuous times in 1967, and he imprinted upon the country the court's role. And he very firmly, in a statement I think that has been recorded in the annals of history, indicated how he saw the court and Parliament and the state reacting. And so that set the measure of the court.
The court functioned reasonably well and was changing and growing to meet the needs of its member states, 6 of which had gained independence from Britain between 1974 and 1983. Grenada, its most southerly member state, had been the home of the Eastern Caribbean Supreme Court headquarters until 1979, when that island's democratically elected administration of Sir Eric Gairy was overthrown in a Grenada revolution led by Maurice Bishop. The People's Revolutionary Government was formed, and the events which followed brought on trying times for the Eastern Caribbean Supreme Court.
All went well until we had the revolution in 1979, when obviously a new court had to be constituted, right? Which was not a constitutional court in that sense, right? And so it became known as the Supreme Court of Grenada.
In the first instance, I think, of the Grenada government of the time, the revolutionary government, to establish its own courts. The then Grenada government thought that our court did not fit within the new constitutional framework and perhaps was too independent to conform with the new environment in Grenada.
But to a large extent, the court found itself in a position where it almost could not function either at the level that it had been functioning before or even at all, because the Morris Bishop regime formed their own high court.
In a way also it was a mutual decision, because I think the other governments of the OECS had come to the conclusion that the court didn't sit comfortably, and their relationship with the revolutionary government was not altogether comfortable. So there was, I think, a mutual decision that the court ought to remove itself from Grenada, and St. Lucia was determined to be the appropriate headquarters for the court.
From its new home in St. Lucia, the Eastern Caribbean Supreme Court recuperated and refocused its efforts on accomplishing its mission: delivery of justice independently by competent officers in a prompt, fair, efficient, and effective manner. Meantime, conflict on Grenada intensified and led to the execution of Morris Bishop and several others.
You must have heard the Morris Bishop murder trial, where Bernard Code was then, and others, prosecuted for murder of Morris Bishop and others. I was then a magistrate, and for 9 weeks I was doing inquiry into this matter, handwriting all this judgment for evidence for 9 weeks. Very trying time of those days.
The trial of the persons accused of murdering Morris Bishop, the trial was practically completed, and the appeals had been heard and determined by the Grenada Court of Appeal. That's the People's Revolutionary Government created Court of Appeal, as distinct from the Eastern Caribbean Court of Appeal. And therefore we determined, the government of Sir Nicholas Brathwaite, the Prime Minister at the time, determined it was time for Grenada to return to the Eastern Caribbean Supreme Court, because the Constitution of Grenada requires that Grenada subscribe to the Eastern Caribbean Supreme Court. That is a proper constitutional court.
We had restored the Constitution, so we are back to square one, right? But you still kept the Grenada Court, because I think the OECS governments were not prepared to accept Grenada back with the court, back into the OECS court, until that trial had been concluded.
First of all, we had to pass an Act of Parliament here in Grenada. We may refer to the Act as the Eastern Caribbean Supreme Court Rehabilitation Act. Passing the Act itself took just a matter of about 1 month. Then going to the Heads of Government Conference, that took less than a week. But there was still some unfinished business. In fact, as we speak now, at the close of 2007, literally there is still some unfinished business, because the Constitution of Grenada mandates, in the deeply entrenched provisions of the Constitution indeed, that the court be referred to as the Supreme Court of Grenada and the West Indies Associated States. Of course, there are no West Indies Associated States any longer, but in very strict terms, as far as the Constitution of Grenada is concerned, we haven't returned to the Eastern Caribbean Supreme Court. Our court is still the Supreme Court of Grenada and the West Indies Associated States, which is just properly a fiction, because you have to amend that provision of the Constitution. You have to have a referendum vote. But in actual terms, the actual restoration of Grenada to the court, altogether it took us 2 months or so, in terms of the nuts and bolts of the return.
Well, the return of the Grenada court back into the Eastern Caribbean, I think, was warmly welcomed, because they had the experience of it before the court broke away, and I think that they were happy with what they had at that time. And I believe that the return of the court was a welcome return.
In those days, work was not heavy. We were able to move about to the different islands, where we had to work. Well, one judge in those days, one judge in St. Lucia, one in Grenada, one in Dominica, St. Kitts one, Antigua one. But the judge in Dominica did the Tortola and also Montserrat.
In the early days of the ECSC, as one may have noticed, judges were all males. In 1983, the panel of judges was complemented with the appointment of the first female judge in the person of Madame Justice Monica Joseph of Grenada.
Some people were a bit taken aback, I must say, because they were, some of them voiced, can a woman handle that job? Isn't it for a man? But it didn't last long. I think people settled down fairly quickly. And how I approached it, I did not expect any particular or any person to treat me in any particular way because I'm a woman or I'm not a man. And I think that the same relates to the judges now who are serving. They are judges in their own rights. They have been appointed because they went through the same courses, did the same study, went to the same schools, to the same colleges as their male counterparts. And so they would be functioning not as female judges, but as judges.
Today, in 2008, the Eastern Caribbean Supreme Court is composed of Acting Chief Justice Sir Brian Alleyne, who is the head of the judiciary, 3 Justices of Appeal, 17 High Court judges, and as of 2001, 2 masters who are itinerant judges with limited powers.
I consider that I may safely state, without fear of contradiction, that the task of judging is an awesome responsibility.
The High Court judges are assigned on a rotation basis to member states and territories. Montserrat is the only territory still being served by a visiting judge.
I am almost amazed at what I hear to be the number of judges in each territory. I'm not suggesting for a minute that they are not justified in having them, because the workload obviously would have increased over 17 years. You have more people, more lawyers, more litigation.
The Eastern Caribbean Supreme Court consists of 2 divisions, a Court of Appeal and a High Court of Justice. Its headquarters in St. Lucia houses the Judges of Appeals Chambers, the Court of Appeal Registry, and other administrative staff. In addition, there are court offices in all 9 member states and territories, which house the chambers of the High Court judges and the offices of the High Court Registry. Each High Court registry is headed by a legally trained registrar who provides the necessary administrative and legal support for the functioning of the High Court.
There are 6 independent states subscribing to the Eastern Caribbean Supreme Court and 3 British overseas territories. In theory, it's one court, but in the law of each country, it is the court of that state. It is the High Court of Antigua and Barbuda. It is the High Court of Grenada.
No, there's hardly anywhere else in the world, at least we do not know of anywhere else in the world. You have one court, which is an international court, in the sense of a court being made by many parties, and at the same time is the domestic court in each of its constituent members. So it's unique in that sense.
And we are the trial court as well as the appeal court of those countries, with limited appeal jurisdiction to the Privy Council. So I don't think there's another court in the world that does that.
This honorable court now resume its sitting. God save the Queen and this honorable.
Appeals from all subordinate courts are heard by the Eastern Caribbean Supreme Court Court of Appeal. It is an itinerant court, traveling to each member state and territory where it sits at various specified dates during the year to hear appeals from the decisions of the High Court and Magistrates' Court in member states in both civil and criminal matters. In the case of Antigua and Barbuda, the Court of Appeal also hears appeals from the Antigua and Barbuda Industrial Court.
You have an itinerant Court of Appeal. It is not based in one place like in Barbados or Jamaica or Trinidad. The judges travel a lot. I sometimes jokingly refer to them as nomads. I don't think they know that. And you'll be surprised to hear that I do refer them as nomads because they travel so much. They're always pitching their tent.
We move from country to country. We sit in the country from which the appeal comes, although there are times for convenience of parties, etc., where we will take an appeal from one country in another country. And this is really to facilitate the parties and to make sure that cases are dealt with as quickly as possible. This situation creates a real difficulty because we have to travel from St. Lucia to Antigua or to British Virgin Islands or to Grenada with bundles and bundles of books, boxes of records and documents. And that creates a big burden on the judges, not only carrying those bundles and having to pack them, unpack them, deal with them, read them, sort them, and so on. But also, it's burdensome for judges to have to travel from their home almost every other week, with a week in between. It's very disruptive to the life of a judge and puts a lot of stress and pressure on the judge.
The final appellate court of the Eastern Caribbean Supreme Court is the Privy Council in London. But following the independence of states and the inauguration of the Caribbean Court of Justice, debate has been ongoing about whether or not the Privy Council should be replaced by the Caribbean Court of Justice.
I am an unrepentant believer in having a Caribbean court as our final court of appeal. I respect the decisions of the Privy Council. I respect the learning of the Privy Council. I respect the integrity of the Privy Council. And I am grateful to the Privy Council for the role it has played in the history of the legal justice system in the Caribbean. But with the coming of independence, all of these territories ought to have made strenuous efforts to localize their final appeal. Now that we have the Caribbean Court of Justice, there is really no good reason why all Caribbean jurisdictions should not be signing on to the appellate jurisdiction of the Caribbean Court of Appeal.
I have absolutely no doubt in my mind that the Eastern Caribbean Court of Appeal matters ought to go to the CCJ for the reason that the CCJ is in touch with the thinking of the West Indian person. They're in touch with the lifestyles of the West Indian person. They know when words are used, what they mean. And therefore, I have no doubt at all that the CCJ would serve the Eastern Caribbean better in many ways, not necessarily interpreting the law. I think that they would be as good as any member of the Privy Council, but I think that they're interpreting it in a context in which they coexist with other people.
The Eastern Caribbean states have not yet moved towards adopting that final jurisdiction. And I think a large part of the reason why we have not done that is because there are certain constitutional impediments in the way. The process to delink from the Privy Council and adopt the final appellate jurisdiction of the CCJ is a fairly complex and restrictive process established by our constitutions, which in many cases require not only special and qualified majorities in Parliament, but also a referendum, majorities in referenda. And that is always a politically difficult decision to take.
The Chief Justice is head of the Judiciary and the Judicial and Legal Services Commission. Additionally, he is charged with administrative responsibilities, including but not limited to the recruitment and welfare of judges. He also sits on Court of Appeal panels and has the unique and challenging task of liaising with all member states and territories.
It does not make or easy to have to deal with 9 different individuals. And that is one aspect, one peculiar aspect of our system. In Barbados, for instance, and the other islands, Jamaica, Trinidad, you deal with one head. The court deals with one head. But in the Eastern Caribbean court, the Chief Justice has to deal with 9 heads.
The Chief Justice is also the head of the judiciary of all these countries and has very significant administrative functions in that connection. The Chief Justice deals with applications for leave, it deals with promotions within the judiciary, the whole question of remuneration and terms and conditions of judges. We have to propose to the heads of government what the remuneration should be, how it should be reviewed from time to time. Issues of housing, when the national government may not be responding appropriately to the housing needs of judges, we have to take those issues up. Security of judges, of courts, and so on. All these are matters that fall under our concern. There's a vast range of administrative duties that the Chief Justice has to undertake. And I have found in the term that I have served as acting Chief Justice that this responsibility is almost overwhelming, so that the Chief Justice has relatively little time to attend to what is the principal function of a judge, which is to adjudicate cases. So it's much to my regret that I have had to withdraw from a lot of adjudicative work to deal with administrative work. The approaches we've taken to that is to get the approval of the heads of government for the appointment of a managing judge or an administrative judge who is intended to take up much of the administrative function of the Chief Justice, while not affecting the Chief Justice's ultimate responsibility for administration of the court.
Most courts belong to one state and are headed by one Chief Justice. But the ECSC belongs to 9 states, with no one government controlling the court. The ultimate responsibility for the court is the conference of the heads of government of all 9 states. Therefore, each Prime Minister or Premier or Chief Minister has a veto on major decisions. Major decisions, including the appointment of a Chief Justice, are based on the unanimous vote of the authority, and commentators have expressed varied views on this issue.
The system of choosing a Chief Justice should be changed, because I think that impacts negatively on our development. Take, for instance, with Sir Dennis Barron. It took him about 3 years before he was appointed. Presently, we have Justice Brian Alleyne. He's in the same category. Because of the unanimity situation, all the heads must agree before a Chief Justice can be appointed. Obviously, one understands the rationale for that, because if you are going to be the Chief Justice is Chief Justice of St. Kitts, is Chief Justice of Antigua, is Chief Justice of the different islands. So naturally, all the heads would want to have an input into the appointment. I think that is the rationale. But to have one acting for 3 years in that position without being appointed, I think, in my view, undoubtedly results negatively, rather impacts upon the efficiency of the court.
Nothing in the instrument creating the court, which is called the court's order, requires that there be unanimity among the heads for the appointment. But it appears that in the way it has evolved, there may be some convention in that regard. If that is so, it has sometimes resulted in grave injustice being done. Now, there's a fundamental difference between America and the Eastern Caribbean Supreme Court in that in America, the president is nominating someone to be appointed onto the U.S. Supreme Court. Yes, you have the Judiciary Committee of the Senate meeting and can fire questions at him, but he has a chance to answer, and it is done openly. So you're not talking about gossip and rumor, unmentionable things. But in our system, a prime minister, for whatever reason or for no reason, can quietly say, I'm vetoing this nomination, which in itself can cast aspersions on the nominee, and that is not fair. So we would like to see that change.
Should the change, I think, but perhaps that should be brought about. The unanimity position will remain, and if one is acting for 1 year and there is no appointment, they cannot agree, I think then a majority should be able to make that appointment. And that would, in my view, eliminate the stalemate which we see occurring time and time again.
While the decision to appoint a Chief Justice requires the agreement of heads of government of member states and territories, appointments at the Court of Appeal and High Court levels are made following an application process. In the past, judges were handpicked by the Chief Justice. But as the court evolved, that process changed, and the prospective jurists are now required to apply for positions at both levels. They are interviewed and selected by the Judicial and Legal Services Commission, for which the Chief Justice is chairman. Once appointed, a judge may hold office until he or she attains the age of 65 and 62 for the Court of Appeal and High Court levels, respectively. The Judicial and Legal Services Commission, acting with the concurrence of heads of government of all states, may permit a judge to continue in his office for an annual period not exceeding 3 years, a policy which has been the subject of much ambivalence.
A judge goes at 62. Court of Appeal at 65. It's not attractive. Good? And then now when you come to get an extension, which you can get, all the prime ministers or premiers have to agree. Good? So that's, again, it militates against your getting people who want to make a career of judges. Good? That should be removed. The age limit should be increased because people are living longer.
The Eastern Caribbean Supreme Court was established in 1967 with its headquarters housed in Grenada. In 1979, following the demise of Sir Eric Gary's administration during the Grenada Revolution, the ECSC severed its relationship with Grenada and moved its headquarters to St. Lucia. Grenada was rehabilitated back into the ECSC some years later, but the court's headquarters remained in St. Lucia. The institution has made rapid strides over the past 4 decades, infusing creative, dynamic approaches to improve the justice system for the people of the region. As you will learn in segments to come, this is a continuous process which bears testament that the Eastern Caribbean Supreme Court is an evolving court.